Okay, Arya, you may start.
Okay. Hello and welcome back to the Legal Podcast, powered by Legal Specs, where we bridge the gap between theory and practice in law. At Legal Specs, we are passionate about empowering future legal professions through practical learning, from internships and courses to the legal publications and mentorship. I'm your host, Arya, and today's podcast is one of every IP enthusiast, law student, and young professional dreaming of making their mark in the intellectual property law. We are joined by someone whose name is synonymous with excellence in IPR practice, a lawyer, a mentor, and an innovator whose work defines the modern IP landscape in India. Our guest today is Advocate Ankit, partner at Mason and Associates, and one of India's most recognized names in intellectual property rights. His expertise span continuously and non-contiguous IP matters, from prosecutions and enforcement to litigation and strategic advisory. Ankit's professional journey is decorated with accolades. He has been recognized as a Legal 500 Recommended Lawyers in 2024 and 2025, and a future star in IP law by Benchmark Litigation, a rising star by Managing IP, and is also featured among India's future leaders by IBJL. And he is even listed in the WTR 1000 for 2025. Beyond the courtroom, he is the founder of Indian Case Laws, ICL, a platform dedicated to simplifying and spreading legal awareness. With a gold medal in law and an LLM in IP law, he brings both academic depth and real world mastery to the table. Welcome to the podcast, sir. It's an absolute pleasure to have you here.
Thank you, Arya. Pleasure is mine. Thanks.
So, starting with the discussion, sir, first of all, how are you?
I'm good, really good. Thank you.
So, let's begin with the story, sir. What inspired you to step into the world of law? And how did your interest in intellectual property rights evolve from here? Like, was it something you've always dreamed of, or did your life made such turns which brought you here?
So, why I chose law as a career or why I became a lawyer was actually not planned as much. When I was in my standard 12th or in school, I had decided that I'll do law because it was probably I was very lazy and I thought it's a 5 year program and let's just I don't have to think much for those 5 years what I need to do next. So there and obviously I was a commerce graduate, and then I realized it's probably the longest course that I can take after standard 12th. So for 5 years at least, I don't have to bother what I need to do with life, and so that's why I did law. Why I did intellectual property was in my third year of law school, we were introduced to the subject of intellectual property, which was divided into copyright and trademarks. And having an interest in movies and reading and stories, I thought that this could be a good career to look for. I also thought of becoming a criminal lawyer when I was in law school, but I thought my interest is more inclined towards this field of law. So yeah, that's how it was.
Okay, sir. So, as you have an impressive journey leading up to becoming a partner at Mason and Associates, what have been some of the biggest turning points or milestones that shaped your path as an IP lawyer?
I really don't know, to be really frank and really honest, what have been turning milestones. See, uh, if you look at it, you can look at it various levels. One could be at a level of experience, one could be at a level of intellectually growing, one could be at a level of doing certain transactions or litigations. But I think certain important career milestones would have been obviously my first job. Then the second career milestone could be the matters that we worked on, right?
Yeah.
Arguing certain matters. For example, I argued a case on registrability of geographical trademarks. That was a career milestone. I was a part of a team which worked on India's first case on reverse confusion by the division bench. Then another case which dealt with single color trademarks. So all of these have been part and parcel of the work, whether they have been career milestones or not, or personal milestones or not. I don't know. Probably being designated a partner is a milestone. Probably getting a gold medal in an LLM is a milestone. But I just did what had to be done at that particular point of time. I Whatever has been achieved is a result of a lot of people behind me and supporting me. But I have not looked at careers as having a milestone career. Probably a legal 500 recommended lawyer tag is a milestone, but I've never worked towards these. These have just come in as a part of the job.
Okay, so as every practitioner has that one case or client that tested them, right? So, what's been one of the most challenging IP matters you have handled? Perhaps a trademark dispute or enforcement action, and how did you navigate it?
See, again, I have handled multiple IP disputes, and a lot of them have been challenging, and a lot of them have been simply easy to deal with. I once did a matter where we were representing a client who was into mobile phones, right? And he was a prior user of a mark. And we succeeded before the single judge. We couldn't succeed before the division bench. But the turning point of that case was that it turned the law on its head. So earlier, for a lot of time in India, the concept was that for a trademark to succeed in a passing of action, you have to prove prior use, right? But
Yeah.
in that case, and certain concurrent cases at that time, this whole concept of goodwill had developed, that not only prior use, a plaintiff who wants to succeed has to develop goodwill. So that case taught me a lot in terms of what's the law in passing off, what to argue, what facts to plead, what not to plead. So that's one case. And then apart from that, I did a whole campaign for a lot of brands. In the sense, campaign means we filed a number of litigations and protected our brand. So when we started with, so let's say, by way of an example, there is one brand, let's say X. So X is being copied by many infringers, right? And obviously they're affecting the market. So we filed few lawsuits, succeeded in 4 or 5 litigations for that brand, stopped the infringers, and by the time we cleared the market, the sales were 5x of what it was initially selling before the infringers were being cleared. So every matter tests you in some manner or the other. In some matters, you are conducting a cross. While the matter may not be that difficult in terms of stakes, but sometimes it tests you when you are cross-examining a witness. Sometimes you are tested in urgency, that the matter has come to you today and you have to file it by tomorrow. Day after tomorrow, the business of the client might stop. So there, at different stages in life or in different stages in the litigation, there are different challenges. One matter could be challenging on one day, and let's say it's an urgent matter, and you're able to get a stay for another 3 years. That matter loses any challenging thing about it, right? So yeah.
So, how do you personally approach a problem solving when those high pressure moments come? Like on a personal basis, everyone has the different approach.
I see, whenever there are high pressure moments, the first thing that you need to tell yourself is it has to be done. You can't
Yeah.
you can't crib about it. You can't make faces about it. You just have to say it's done. When it's done, I am through with this. I'll not come the next day. So that's the first thing I tell myself. Let's just finish this. After this, I'll not see anything. Obviously, you have to see it the next day also, but that's the motivation that I give myself. Okay, just this night. So whenever high pressure moments come, for example, you have to again file a matter, or you are in the middle of high stakes argument matters, or the client has just immediately called you that this has happened and I need to take an immediate action. So first thing first is never react immediately.
Okay. That's
Understand
a
the
really
whole.
good lesson.
Never react immediately. First and foremost, understand the issue. Take 5 minutes, take a breather, think about what needs to be achieved, and then work on it. Because I have seen a lot of things look urgent, pressures are put on you that this is urgent, this has to be done. And when you spend 10 minutes on this matter, that this is the problem and this is the solution, you probably think that this is not anymore urgent, or this can be put off for 2 days, or urgency may cause a problem in itself. So my advice in high pressure situation is just first for 5-10 minutes, just listen, analyze, see if there is a solution which is better. Don't straight jump onto it. If your boss says draft a plate, I want it 24 hours or something like that, just understand the problem first, see where it is headed, what is everyone looking for, and then probably do it. Because I've realized that sometimes in urgency you miss critical documents, you miss putting in critical facts. So I what I try to do is I first is motivate yourself that this too shall pass. It's okay. Second is take 5-10 minutes to just understand what is required to be done. That's all.
Okay. Okay. So, everyone has some mentors and role models in their life. So, who has been some of your mentors or models, like people who inspired your professional journey or influenced the way you approach the intellectual property law, like the professors or some of your friends?
To be really honest, I don't have a professor or a teacher who, as far as IP is concerned, it has always been the seniors or colleagues who I've worked with. So, starting from my first job, both my two bosses, Mr. Sagar Chandra and Shani Chandra, they have been my role models. They inspired me. I learned different skill sets from both of them. How to approach a matter, what needs to be resolved, how to deal with the client, right? And I'll tell you a funny anecdote. I That was my first office, and a lot of times your senior doesn't in internships they don't tell you to check your emails, right? So when I joined them, I used the only thing my law was good, my facts were good. I knew I used to read documents and every research was proper. But the only missing link in the whole journey was that I didn't check my emails.
Okay.
So my boss told me that Ankit, please put a placard on the front of your monitor that every morning I have to check all my emails. And after that lesson, I have never missed an email.
Okay.
But somebody has to give you a jolt, I think. So
Yeah.
that's one. Then my role models have obviously been the stalwarts in IP who have defined IP in India, who have really told us or taught us, or even the judges, that what intellectual property is all about. Then I've worked in an office called Rahul Chaudhary and Partners, where I liked how one of my partner Naval used to work, and even my current boss, Mr. Mason, I look up to him because he also, again, you tell him a problem, he'll take 10 minutes to just slow it down, understand it, and then give an advice which is legally tenable and also sound for the business. So yeah, so these are the people. I think also certain judges who practiced IP, certain senior advocates who practiced IP. Because I've only practiced IP. Obviously, the senior advocates have practiced other laws as well. But in this domain, these have been certain mentors which you learn by observing, imbibing, being with them in the court, I guess. So yeah, that's about it.
Okay, so as in current scenario, many people still see the IPR as something optional or technical. So, what's one of the misconception about IP law that you often encounter, and what's the reality?
Misconception among students, misconception among members of the public. How would you do you want to categorize, or should I answer both? I mean, how do
Uh,
you
so you can first go with the students and then the public.
see? I have not found after I joined the profession a student who doesn't who has a misconception about IP. To be really honest, because see, at the end we are all law students, and when we read the subjects, we know there is a difference between trademarks, patents, copyright, and designs. When we delve further, we obviously understand how each is different from each other. But I think maybe this could be one, but that students think that intellectual property is only about filings and not litigations. That could be one way. I've seen a lot of interns or students that have not delved into any aspect of enforcement or litigation as far as IP is concerned. They worked in prosecution offices which are heavy into prosecution, done trademark filings, copyright filings, and they think that's the whole and soul of practice of intellectual property. As far as laymen or members of the public, or even some of my family members who I have not been able to explain what I do uh, in all its length and breadth, think that intellectual property is first thing is it's property. They forget the word intellectual out of it. So I'll tell them I'm an intellectual property lawyer, and they say, "Oh, property lawyer. ठीक है हमारी एक जमीन है XYZ." That's not what I do. And then I try to explain them that uh, what I do actually. And then I think because of lack of awareness, there is this gap that they understand patent, copyright, and trademarks to be synonyms of each other. For example, for one thing, they will say इसको patent करा ले, which is a subject matter of a separate law, और ये copyright हो जाएगा, which is probably a subject matter of an invention. So there is this misconception. I think. Um, yeah, I think that's how I'll answer it.
Okay, and what would be that one advice which you'd like to give to someone who is who's doing their master in IP law?
Uh, okay, if they're already doing their masters, so I think it's a part of their curriculum to read across comparative jurisdictions on what the subject has. For example, read law in UK, or what is the international law. But if they're doing their masters, see again, this question has an inherent issue. I'll tell you what. Somebody who's doing his masters immediately after college, somebody who's doing his masters after 5 years into litigation, and somebody who's doing his masters after attending a prosecution office, or somebody who's done corporate law come to intellectual property for his masters. So it's very difficult to answer the question, but let's just put a general advice would be to somebody who's doing intellectual property. I think the advice would be to always deep dive. uh,
Okay.
what I have realized over the years in the profession, that there might be 100 lawyers that might be practicing intellectual property. They know IP, no problem. They know trademark law, they know copyright law, no problem. But sometimes there are very nuanced questions on interpretation of provisions which are intermingling among the statutes, may have a larger impact on how should I, jurisprudence in IP in India, may have some principles borrowed from other countries. So unless you deep dive on the how, why, what, and all of IP, for example, in copyright, if you know what was the first statute, where it came, what are the first conventions on it, how has our statute progressed with the world, so you will be able to give a far more holistic advice, which will not only be local in nature but may also be global in nature. So I think that's
Okay.
deep diving.
Okay. And so looking back at what was your one mistake that you made earlier in your career? Maybe like a client interaction or a procedure setup or just overconfidence. And what valuable lesson did it teach you?
Only one we have to tell, huh? That's
Yes,
fine.
and except from not checking the emails.
No, no. Once I missed the. See, there are mistakes which we do almost once a week or two times in a month. Everybody does some mistakes. So, but mistakes that teach you, I'll tell you a few. Uh, if so, once I was drafting a written submissions in a matter,
Okay.
and the written submissions were based on the. I was for the plaintiff, so the written submissions were based on the arguments in the plaint and the replication. Okay, and opposite sides written submissions were based on the written statement, right? So
Yeah.
when I drafted the written submissions on the basis of the replication, there was a line that the sales of the plaintiff were so and so. Okay, fair enough. Now the replication didn't say for what period. It just said the sales of the plaintiff was so and so. Okay. So I checked the date of the replication. What is the date of the replication? The date of the replication was February 2014. I still remember.
Okay.
And I said in my written submissions, I wrote that the sales of the plaintiff till February 2014 were so and so.
Okay.
Logical assumption. He gave his sales and the document is dated February 2014. I didn't verify it from the client. And we filed those written submissions. And the opposite side said, my lords, please look at their written submissions. They say till February 2014, their sales was so and so. Now, the relevant date of sales was till 2012. So, ideally, I should have asked the client what were his sales till 2012 and what are these sales for which period to which period. I should not have assumed these are for February 2014. And hence, those
Okay.
sales were not considered despite being pleaded in the replication. So, that's one mistake. Whenever you are putting a factual document, get it verified.
Okay.
Don't, I have something to back it. It's in the replication. Nobody can dispute it. But why did I write February 2014? Okay, that's the date of the replication. But that could be wrong. So that's one thing that happened.
Okay. So, apart from all the academic skills, for today's law student dreaming of a career in IP, what are the key skills that they should develop beyond academics? Like, is it networking, commercial awareness, or something else entirely?
I think beyond, let's just put academics means their curriculum.
Yeah.
So beyond that, they can read a lot of things, no problem. Beyond their curriculum, a law student, a student who wants to learn IP can understand how, in my opinion, they see if they've read IP, what should they do? See, my view is they should read books on how brands work, how marketing inputs are put, how advertisements are made.
Okay. So, can you suggest some of them, like the names
There
of
is
those
Thinking
books?
Fast and Slow. Uh, that's one book I can suggest. Think Fast and Slow. But I'll tell you why I'm saying this.
Okay.
And this is very important. And when I told this to a senior advocate, when I told this to my boss, she believed it. When my boss told it to a senior advocate, he didn't believe it. When I told it to my father, he didn't believe it on the first time. When I showed him what I'm saying, he then believed it. So every brand has a color, a primary color. Let me give an example. Nivea has a color,
Yeah.
Cadbury has a color, Kit Kat has a color. Um, let's say airlines. Indigo has a color,
Yeah.
Vistara has a color, Air India has a color. Let's go to banks. HDFC has their colors, ICICI has an orange color, right?
Yeah.
Okay, again, coming to Fruity has its color, Fanta has its color. Okay, so we had a matter where we were sued for passing off in color scheme, and our argument was that we are using a primary color. Okay,
Okay.
and I had a theory, not a theory, but I had observed this after watching TV for all my life, that brands try to put the clothes of their color on the person who's promoting them or who's their lead actor in the advertisement. So a Ritik in a Coca-Cola ad will be wearing a red color. A Tapsi Pannu in a Nivea ad will be wearing a blue color. So when I'm putting that ad in front of the viewers, they get a color recognition with the product. So in our case, it was a biscuit which was promoted by a cricketer who was wearing a particular t-shirt, which was the primary color. And I told it to my senior. She was convinced. We told it to a senior advocate who called us stupid. I told it to my father. He didn't believe me. Then I showed him ads, A to Z ads, a Nivea ad, a Coke ad. Why do they have red in background? Why is it so heavy? Why does the stevia ad has so much of green? So I didn't learn it in academics. I learned it by reading or probably watching a lot of television and observing. So the perspective is read as much as you can, have a holistic knowledge as much as you can, observe as much as you can, see how marketing things and how lawyer things are very different. But when you got to protect a brand and you have to prove its goodwill, you have to think how marketing is thinking. Why marketing did what it did. And for that, you probably have to read books on marketing.
Okay. Now it makes so much sense that why colors make so much sense in the advertisements. Okay. Moving on to the next
Can
question.
I just interject? Just
Yeah.
have you been to airport?
Yeah.
When you enter inside, you look at your relevant airline.
Yeah.
Subconsciously, next time, now you will not be able to see Indigo, Vistara, or Air India. You will see the color and move towards it. Observe that.
I mostly do that. Like, yeah, if it's blue color, then it has to be indigo. If it's purple, it has to be Vistara. Yeah, now it makes so much sense. Okay, moving to the next question, sir. So, you've built a reputation at the intersection of IP and innovation. So, how do you think lawyers should embrace technology and AI, especially with tools now capable of drafting, searching, or even identifying IP violations?
See, my view is it's a hybrid game. You cannot. Okay, the first thing is AI is based on LLMs. So AI will not tell you anything unless it is feed in its system.
Yeah.
Okay. So obviously feeding in its system is not an automatic exercise. It does it by probably internet crawling, probably reading books, probably scanning books. But it cannot be 100% updated with what is happening. For example, if there is a notification today, AI may not know it. If you are asking an opinion on 31st of October on a notification that has come on 30th October, AI may not know it. So that's one. So you have to be very sure when asking an opinion. Number one. Number two, I think AI is excellent in giving you a draft, but it's not excellent
That.
and tailor-made for the client.
Okay.
So you can take the best from it and then modify it as per client's requirement. So what happens in law? Sometimes they ask, "Yaar, I need to file a suit for trademark infringement. Do you have a draft?" Okay, you send the draft to your friend, right? So they'll ask AI, I have a suit for trademark infringement, these are the marks, this is the copying that is happening, this is the plaint, this has to be filed in Delhi High Court, please draft the plaint. It'll draft the plaint, right? And it might today might it might be a plaint which is doing 20% of the job, right? You'll have to fill in 80%, but there is no harm in asking it. I'll tell you why. Sometimes I come from a different background, you come from a different background. For the same thing, we might say it differently. Depends on our schooling, our tutoring, home, everything. A same thing may be said in 17 different ways, in my opinion. 17 is just a random number, it's not nothing mathematical about it. But it can be said in different ways, right? The same thing. So AI is one way of looking at it. You may appreciate it, but you can get an idea. Probably
Yeah.
this is something that will work. Probably, okay, let's say you want to say this is wrong, or you want to say this is pathetic, this is dismissive. You want to use a word, but a word which might not be proper to put in a legal draft. The AI may say it's in bad taste. So you get that idea.
Yeah.
So, for example, in words, I used to do this a lot. I used to use a lot of that right click on synonyms and check which is following better. Right? I still do it. So AI may give you certain options. So embracing, yes, embrace it. I have my own problems because I read somewhere that it uses a lot of water to give you a search result. So I have my own problem of not using it. But keeping environmental concerns aside, as a technology, I think it is fantastic. It gives you results in 20 seconds, not more than that, in my opinion. 20 seconds is also on the higher side. I wanted to once prepare a draft for a post for hiring an associate, and it gave me a result in 20 seconds, which I would have taken at least 10 minutes to draft. So it gave me a result in 20 seconds, another 2 minutes for me to work on it. So I think it is something helpful. It saves your time, but should be utilized at this level, I think, only for drafts which are not advisory heavy, are not policy heavy, which if there is a wrong fact in it, it doesn't affect any person. But otherwise, I think due diligence is still required. Uh, there is always see LLMs based information will have see AI at the end of the day will have a structure, right? And you know probably how the what the client looks for, or what the law has been set, or how has this word in this section been interpreted, which it may have, it may not have, right?
Yeah.
So adopt it, but use it wisely. Don't use it like, okay, the draft's ready, let's just send it to the client.
Okay. So, if you could go back to time, then what would be that one piece of advice you can give to your younger selves, like when you were in law school?
In
Like,
law school, okay.
yeah, the version of you just discovered IP law. What would it be?
See, if you are in law school, I will not give you any piece of advice, because I think law schools are places to study and enjoy at the same time. So I won't give ki moods kar lo, ya lectures attend kar lo, internships kar lo. I won't give all of that advice. I think make friends, make lifelong friends, which help you in thick and thin. That's something which is very important during your school or your law school. Get the basics right of every law. Get the basics right. In 10-15 years down the line, if you are not aware of basics, you will not be able to practice other laws. So your basics of certain laws should be absolutely right. Don't do moods, it's fine. Don't attend lectures, fine. Don't, okay, some viewer might just be saying, what is he saying? But just get utilize your law school for making lifelong friendships, making connections, and getting basics of almost every law right. Ask difficult questions to your faculties. Ask why. Why are you saying so? Once I'll tell you. In my LLM, one of my professors said that uh, in some foreign country, the administration was taken away by the king from the church. So na, in law school, we read church was ruling at some point in time.
Yeah.
So I just asked the question, why didn't the church protest? But my
Quite
faculty
logical and reasonable.
because it wasn't written in the article.
Yeah.
So ask these difficult questions. Ask always why, what, how, when, where. I think that's what I'll advise somebody in law school.
Okay. So finally, how do you see the role of a young lawyers evolving in the shape of the future of IP and innovation in India? Like, what can they do to contribute meaningful to this space?
See, I think every generation brings its own things to the table.
Yeah.
Uh, Now, this generation is so tech savvy. The ones who would be graduating in, let's say, 2025, 26, they'll be extremely tech savvy. They'll know everything about Google Forms, online meetings, recordings, how to utilize AI, what's the fastest way to do a research, uh, what shortcuts are there on Manupatra or on SCC. So I think they'll bring speed to the table. I think they'll bring a lot of speed to the table. But at the same time, I think they need mentoring because obviously every young lawyer needs mentoring. I think they still have to be told that speed is good, but at the same time, what you researched, worked on, drafted has to be fact checked on every small thing that you've written in it. For example, I used to have a practice. If I'm drafting a document and I'm putting any fact in it in that document, I'll not put it unless I have a backing document to support it. I will not even draft anything which is beyond what has been given to me. That's another story that I go on the internet and search myself. What the client has not told me. But in the draft, I won't put anything which I can't back up unless
Okay.
there are demands towards it. One can only do so much.
Okay. Okay. All right. Now it's time to shift the gears and have a little fun with our creative segment, the IP corner.
Oh, I thought we were having fun till now also, but okay.
No, apart from that,
Okay.
so this is where we step away from the legal jargon and get to know the person behind the practice. So now
All right.
I'm gonna ask you a few questions. So every advocate, every lawyer, every practitioner has that one unforgettable matter, like maybe a case that transformed their understanding of law or the importance of IP protection. So for you, what's that one particular case that changed your perspective as a lawyer?
Uh, matlab my case or generally any case which changed my perspective.
Some case which you have been a part of.
See, again, the example that I gave you, that yellow, the cricketer wearing the yellow, that case changed my perspective a lot. Before that case, I had very limited knowledge on how law of passing of works, and then I realized that for colors you need to have a higher standard to prove goodwill, to claim exclusivity compared to words. And I also realized that in every case, the three ingredients or the three trinity of interim injunctions, you don't have to argue and delve on all of them. If you're able to satisfy the court that the opposite side doesn't have a prima facie case, the, the court need not go into balance of convenience and irreparable harm. Then similarly, if you're able to convince the court that the plaintiff has no goodwill, then the court will not go into confusion. So let me give you an example. Let's say there is a plaintiff who launched 1 day ago before the defendant. 1 day before. And for some reason the products came out to be identical or similar, right? Still then the court said that since the plaintiff doesn't have goodwill, I'm not going into the fact that defendant's product looks similar or not. So you don't have a right to say that somebody is copying because you don't have a right in goodwill. So yeah, that case taught me a lot. A lot of cases have taught me over the years. They've changed my perspective. This one did. And apart from this, I think there was there's this matter on keyword advertising which changed my perspective on how to look at things. Where court said that utilization of keywords is not a for triggering of ads is not a violation of trademark rights, because at the end the consumer looks at the ad. When he sees that the ad doesn't have the infringing trademark, then obviously there is no violation. So yeah,
Yeah. Okay. So now let's see how fast can you simplify something complex.
let's see.
Okay, and you have 60 seconds to break down one of these tricky IP concepts for our listeners.
Okay.
Explain doctrine of transborder reputation.
Okay, doctrine of transborder reputation is that the product is not available in India to a large extent. It's probably available in a limited extent, but the goodwill of that product or the reputation of that product from another country, for example, Gaps, or let's say another foreign brand, Tesla or something, is so huge that India, your domestic country knows about it, and hence when your domestic consumer knows about that foreign brand whose reputation has traveled across borders without there being a physical product, then also that reputation can be protected. That stands for the reputation. I think I've done it in less than 60 seconds.
Yes, sir. Okay, second question. Parallel imports and exhaustions.
Parallel imports and exhaustion. Parallel imports is a concept where, suppose you're selling a product in India, and that same product is of under a particular trademark, and then in another country a product is being sold, let's say US, and in US the product is then bought genuinely by someone and then imported into India. Then you don't have rights to say that he's an infringer by way of import, because he's genuinely taken that product from USA. So that's why can't call him an infringer. So this is a parallel import from USA, which he's doing of that product under that very trademark. But he's saved because he's genuinely purchased the product. And why it's called exhaustion? Because it's an exhaustion of your trademark rights in US. Because once you've sold the product, your rights get exhausted. So that's parallel imports and exhaustion.
Okay, moving towards the coffee table judgment, and you have done so well in this round. Congratulations.
Thank you.
Okay, so you have probably seen your fair share of amusing or unexpected moments in the court or client meetings, right?
Right.
So tell us about a funny, quirky, or memorable experience, like your coffee table judgment that you've always get laughs on.
So I'll tell you something in court that happened, and this was very recent. So a lawyer said, "My lords, I'm in a difficulty. I'll not be able to be available on this date or today. It's my marriage." So the judge said, "Oh, then you are in a bigger difficulty." He said, "My lords, why? Because you've not invited any of us." So that was one. Second is, once we were briefing a senior counsel in a matter, and our mark was rectified. A trademark was rectified. So, for example, if it was a label mark, one of the words was held to be disclaimed or not protectable. And we were briefing him that, so this is what has happened. And after 2 hours of the briefing, when we did all the briefing, he asked us, "Was your mark registered?" So basically, it can't be rectified unless it was registered. So we realized that after 2 hours, probably we've not been able to explain him what the matter is all about. I'll give you a very funny incident.
Sure.
You know what's the USP of selling Complan?
What?
Is probably, I think it says increase in height. You if you drink Complan, it
No,
increases.
I was a Horlicks girl from the
So
start.
I'm coming to it. So once there was a matter between Horlicks and Complan, and
Okay.
one of the senior counsels representing Horlicks told the court that Dharmendra used to drink Horlicks.
Okay.
Okay, and he in jest said that probably Amitabh drunk Complan. So I said I in the ears of my senior I said Amitabh was taller. So my senior said to the court, well, that's why Amitabh was taller. He had Complan, and everybody had a good laugh.
Okay.
So I'll give you fourth incident. No, that's not that funny, but everybody laughed when it was done in the court. So it was the next day after Independence Day.
Okay.
So everybody had leave of Independence Day, and the next day they had come to court.
Yeah.
And I wanted to get deleted in the matter. I was for a client who wanted to get deleted in the matter, and
Okay.
plaintiff had no objection, or there was something. So, and the judge was hearing that matter as a part of part heard. So he had a bunch of matters, and he would have heard the matter and gave it to the roster bench. Okay. So I said, my lords, I have a very small submission. I want to be deleted from the matter. I've complied with all the orders, and the plaintiff also has no objection. You go to the roster bench. I will not pass an order. So I said, my lords, let everybody else go to the roster bench and let me be independent from here today. So then everybody laughed, and yeah, but I didn't get deleted on that date. I got deleted 6 months later. But yeah,
Okay.
but she laughed. The judge laughed. Everybody at the bar laughed, and she said she laughed but didn't give me the relief. But sometimes I must tell you, if you have a good gap, if you have a good knack, sometimes keeping the moment light when it's very serious may help you. Not
Okay.
every time you have to know how to crack your jokes with the judges, but you have to take the best jokes in the court work which are on yourself.
Okay.
So if the judge is against you, I've seen a lot of seniors. My laws probably today I have got from the wrong side of the bed. So that's one. So yeah, so things like that. Sometimes judges say we've read the provision, we are not with you, right? Then you have to have a clever repartee. My lords, so I'll give you one example. Uh,
Okay.
so once there was this matter, I don't recollect the exact words, but one of the counsel was arguing a lot, right? So the judge said, Mr. So and so, this is a great and wonderful journey we are taking along with you. Does it have an endpoint? So the senior counsel said, my lords, definitely it has an endpoint. But let me take you through the certain important light posts first.
Okay.
I'll give you another example, but this is not that funny, but it's very interesting.
Yeah, sure.
So we were appearing for a client in a trademark infringement and passing of suit. We were briefing a senior. And with our senior was taking the court through our awards, accolades of the brand, how big is the brand. So the court asked him, Mr. So and so, I know all of this. You move further. Okay. So he said, my lords, is the defendant admitting to all of this? Defendant said no. Then, my lady, I have to take you through this. So yeah.
Okay. Now let us move to something really fast, you can say. This is a rapid fire round.
Okay.
Okay. So there are these short questions,
Okay.
and you have to give short answers and no overthinking.
No, it's a rapid fire. How can I overthink?
Yeah, you just have two
Idiot.
seconds.
Yeah.
Okay. Question number one. Favorite IP related case of all time? No overthinking. Your time is going on.
MMT versus Google.
Okay. A brand you admire for its IP strategy.
Um. Oh, I'm so sorry. A
Five
brand I
seconds.
admire. Just a second. A brand I admire for its IP strategy.
Yeah.
Officer's choice.
Okay. Favorite legal book or author?
Favorite legal book is Before Memory Fades by Falias Nariman. Favorite author. Can be legal, non-legal.
Yeah, anything. Can be fictional also.
Favorite author. I'll get back on this one. I've read a lot of books. That's the problem.
Okay. Okay. And your go to coffee order before a hearing?
My go-to coffee order before a hearing.
Yeah.
So my go-to coffee order will be the coffee. The question should be my go-to order before the hearing.
No, no, the coffee. Like what kind of coffee you used to have? Like the espresso shots or black coffee, something.
Oh, I'm not a coffee person, but at the Delhi High Court, I take the cold coffee without sugar and less ice.
Okay. And a trademark you think is genius.
Pioneer. I think
Okay.
that's a great
And
trademark.
okay. And a dream city to argue an IP case in.
Oh, Delhi. There is no doubt about it.
Okay. Now my final question.
Yes.
If not a lawyer,
Yes.
what would you be?
I would have been a stand-up. I wanted to be a stand-up. I wanted to be a radio jockey. So my second career option, I must tell you, I thought if I don't get selected in law, I'll do a mass communication and become an RJ.
Okay. Now this seems like a lot too much different field from this.
No, no, we are still stand-up comics. It's just that we are in court.
Yeah. Okay. Makes sense. Okay. Now, so can we go back to that question of your favorite author?
Hmm. Give me some time on this. All right.
Okay. You have 2 minutes.
Okay.
I gave you plenty of time. It can be someone from your favorite comic, I guess.
Oh, then if we can pick from comic books, then my favorite author is Sahil S. Sharma.
Okay. Okay. And okay. And to wrap up with this segment, now, what's your prediction for the future of IP law in India? Like, will become AI a co-author or will trademarks go digital only? What's that one big shift you see coming in the next decade?
I think IP will be utilized. First, the IP will expand. In my sense, what protection it offers, it will expand in the next decade. All right, what forms can be protected, it will expand. IP will be utilized as a tool to protect intellectual property as and a lot of works which currently do not fall within the domain of intellectual property.
Yeah.
Um, then IP will also be utilized to restrict certain AI generated work which may not be completely true. Um so that's so and see, I've always maintained this, that as the education in the country goes, any country where the education is on a rampage, the intellectual property industry will definitely grow, because as long as people are made aware of their rights, they understand that there is a right to their personality, there is a right to their publicity rights, they have a right on their brands, they have a right on their inventions, they have a right on their writings. When they'll understand and have a knowledge that these are monetizable rights, then that practice will obviously grow, the protection will grow, the applications in the registry will grow at trademark, patent, copyright level, and even the enforcement will grow. So yeah, I think.
Do you think AI is a threat to upcoming lawyers?
I think AI is a threat to upcoming dumb lawyers.
Okay. This particular statement, I guess, gave a lot clarity to each and every laws professional out here.
I mean, see, don't take it as a threat. Never take technology as a threat. Emails were always a threat to post offices. Both are working.
Yeah.
Laptops were a threat to typewriters. Typewriters went by. So a product can go, but an individual will remain. But you can't make it the whole and soul. See, I once gave this quote.
Okay.
This is an old. I've not given this quote, but it's just an observation. Today, at least 2 to 3 hours are being spent on reels, stories, and content. No problem. We need our space. We need to see. We need to know even from what is going on at social media. But at the same time, AI is reading your books. It's
Yeah.
probably reading everything written by Jhumpa Lahiri, everything written in Oxford, everything, every law book, every SEC. It's probably scanning and reading it. And you are here not preparing. You're you're thinking that AI will help us. It will help you only if you help yourself.
Yeah.
I think that's the key.
Okay. So before we close, one last question.
Okay.
What's your key piece of advice to young lawyers and students who want to build a serious career in intellectual property law? Something they can start doing right now to prepare for the success.
I think for intellectual property law to make a career, you need to read a lot. For any law, in fact, you need to read a lot.
Yeah.
You need to know the relevant people in the industry. No, matlab, first so you know that he's the relevant person in the industry. Then how you will reach them is another issue. So that's second. So first is knowledge of the subject. Second, knowledge of the relevant people in in the industry. Third is how is this industry working in the sense of how do we monetize IP as an individual, as a business, and as a lawyer. So when a client comes to a lawyer, the lawyer should be so well read in IP that he should be able to tell the client that this is your business. These are the intellectual properties that you created. These are the possible intellectual properties that you may create. And these are the possible ways that you can protect them in so and so budget. So this is what a lawyer is supposed to do. As
Okay.
a student, you need to know what types of businesses are there: e-commerce, pharmaceutical, retail, what IPs could be involved in each of the businesses.
Yeah.
Even its business know-how, business methods. How are they? Why are certain e-commerce websites still better? Why do we go to Amazon? There is a
Yeah.
reason why do we go to a particular app. What are they doing different? So all of this probably could be protected in intellectual property depending on how they've dealt with it. So I think students and should understand the practicality of the businesses. I think we've lost Arya from the video.
I am so sorry. I think
It's
it was my
okay. It's all right. It's all
yeah.
right.
Yeah, you may continue.
No, no. I was done with my answer. Thank you.
Okay. So this one last question from my side,
All right.
personal on my personal behalf.
Yes.
So you started from the scratch or you had someone support when you started with this career journey?
Oh, I started from scratch. I had no support whatsoever. Matlab,
Okay. And
what do you call support? See, I had my parents who were supporting me, but my parents are not lawyers. My father
no,
is
not like as your parents or your friends, but someone who already was in that industry and helped you growing in it.
no one. No
Okay,
one.
so you started it all by yourself.
I did it all. And matlab, I may look sound pompous or overconfident, but yeah, I did it all by myself. I actually I'll tell you something. Now
Yeah.
let's now since we've started this question, I had no, I have no legal background whatsoever till
Okay.
I did my law, right?
Yeah.
So I'm the first practicing lawyer in my entire family. Uh, then I joined. I was some law firm had come in my college
Okay.
to interview us, and around 20-25 lawyers were, matlab, students interviewed, and they selected five for the second round. They gave internship to those five, and uh, and then from those internships they selected the one they wanted. This was just one job, but five potential candidates. So when
Okay.
that managing partner came to our office for giving for the interview, I read everything that he has done on the internet till date.
Okay.
Every all his matters, everything that the internet can provide me, I read everything. And when he asked questions, I tried to put this. This is what you've done in this matter. This is what you've done in this matter. And he was highly impressed. But unfortunately, for some reason, because there were five internship slots, he couldn't give me an internship because his office had a limited space. So he said, Ankit, if you want to learn intellectual property, I'll teach you. But currently, I don't have space. I am recommending you to another lawyer who practices criminal and matrimonial law. You join her. If you don't like that practice, I am always there if you want to learn intellectual property.
Okay.
So then I joined a firm. It was a chamber practice, three four lawyers, one lead lawyer, and I did around for 6 months. I interned, got a job at that place, but I didn't find my what's the word? I didn't find my calling in matrimonial or criminal law. Criminal was still fine. I didn't like practicing matrimonial law. So then I met Mr. Sagar Chandra in the Delhi High Court. So okay, I'll give you full details. So I was doing a dissertation on copyright law in my final
Okay.
year, and my topic was Copyright Amendment Bill of 2010, which became the law in 2012. So I was in 2011. I was looking for. I was working with this matrimonial lawyer, and then I saw a matter before the division bench of the Delhi High Court in which Mr. Sagar Chandra was sitting. The matter was about whether the Copyright Board has powers to pass interim orders, right?
Yeah.
So I then randomly, I just saw him at the Joint Registrar's court, and I said, "Hi, are you Sagar Chandra?" He said, "Yes." I saw you that matter before the division bench, so and so. He said, "Okay." Then he said, and he and Ishani ma'am had just started out in 2009, and he gave me his card at the moment. I'm looking for juniors at the court itself. And he gave me his card, and I don't know whether he was looking or not looking. That I don't know. But he said that I'm looking for juniors. This is my card. You can let me know. And uh, so I was the first junior when I joined his office. So I went there, gave an interview, had chola kulcha with him at the time of interview. He said, "Are you hungry?" I said, "Yes." So he ordered a chola kulcha, and we ate. He didn't eat. I ate. बेशरम था मैं, but मैंने खा लिया. So and then I joined him. So yeah, so I've had I didn't had any connections, but yeah, I guess just things just fall in place.
Okay. Okay. So, and that brings us to the end of this episode of the
All right,
legal podcast.
all right.
And a huge thank you, sir.
Thank you.
And also a huge thank you to our listeners. If you enjoyed today's discussion, make sure to follow Legal Specs on Instagram, LinkedIn, Telegram, and YouTube for more expert led conversation like we had today. And for more internship opportunities and legal learning resources, do follow. And until next time, I am your host, Arya, signing off from the Legal Podcast, reminding you that in law, ideas are your assets and protect them wisely. And thank you so much, sir, for joining.
Thank you, Arya. Pleasure is all mine. Thank you so much. Thank you
Thank you
for
so
your
much,
time.
sir. I think we are done.